Hello everyone and welcome back to the channel. Hope you're all keeping well. And thank you for everyone who's watched the previous episodes. If you haven't, do recommend you go back and watch those. It's a bit of a logical progression through the journey of a criminal case. And thank you for everyone who's subscribed so far. I'm very pleased to see that we've got over 10k subscribers after the first month and a half, so that's really exceeded expectations. So hopefully we're helping explain some of this quite detailed, complex law in a bit of a simpler way, both for just a taster for bar course students, but also for the general audience. If you do know anyone who's going through a criminal case, you get a better understanding of the procedure that takes place. So today we're on chapter 6 in my series, and this is about disclosure and case management, so what the prosecution must reveal and how cases are managed in court. So just a recap. So we've looked, chapter 1, we've looked at the structures of the court, then we've moved on to arrest, what the police must do, what powers they have, and then we've gone through to look at bail, and also we've looked at the types of evidence as well. And now we're looking at chapter 6, the documents. So we've learned about what type of evidence there are in chapter 5. And now we're going to see what evidence needs to be disclosed by both parties in the trial. So when someone's accused of a crime, the evidence the state holds can decide everything. So the disclosure is about one question: what must the prosecution reveal? And remember, in the UK, we're currently, at the time of filming, we're basing all this on Blackstones Criminal Practice 2025, so it's only accurate as of time of recording. But we're looking at England and Wales law in particular. So the prosecution is handled by the Crown Prosecution Service, and they either send their legal team, counsel, or they appoint a prosecutor to prosecute on their behalf. And often the key deciding factor as to how strong the case is against the defendant is how much evidence the prosecution have. So we looked at, in one of the earlier episodes, about charging. In England and Wales, the Crown Prosecution Service is the main body which decides on charging, and they've got their own tests that they have to look to see if the evidence meets that, whether there's sufficient evidence to convict, and also whether it's in the public interest also to convict. So it's not just paperwork, it's the line between a fair trial and miscarriage of justice. So in this episode, we'll lift the lid on how evidence is shared, how cases are managed, and why transparency is the backbone of justice in England and Wales. So by the end, you'll know exactly what's meant by disclosure, the rules that control it, and how judges keep every case trial ready. So the starting point for the duty is the Criminal Procedure and Investigations Act 1996, or CPIA for short. And it sets a continuing duty on the prosecution to reveal any material that could help the defense. It's an obligation. So think of it as the legal version of turning the lights on. The prosecution cannot hide evidence that might assist or undermine. So this duty is backed by the Criminal Procedure Rules, Part 15. And it's also guided by the Attorney General's disclosure guidelines. But every officer, from the detective to the reviewing lawyer, must grasp that the job is not to win at all costs, it's to ensure justice is done. So the initial details: before a first hearing, the defence is entitled to see what's called the initial details of the prosecution case, or IDPC. And usually that includes something called a MG5 summary, witness lists, and any key statements relied upon at this early stage. But why? because defendants and advocates need to understand the case before they enter the plea. So we looked at, in the summary of where we are in the process, I forgot to mention, we looked at Chapter 2 was looking at police powers, and Chapter 3 was the plea, so the first hearing. So to decide on whether to plead guilty or not guilty, you need to understand the evidence against you. So it's important that the defense has access to all of the evidence that's disclosable and is going to be used against them to decide what option is best when it comes to plea. Under the Criminal Procedure Rules Part 8, these details should be served promptly. It's about early engagement, not trial by surprise. So the CPIA, that's the legal test. So once the investigation's underway, the CPIA draws a clear test. So material must be disclosed if it might reasonably assist the defense case or undermine the prosecution case. And that's deliberately a low threshold. It might assist, not definitely will. And officers and prosecutors have to keep asking, does this note, does this CCTV clip or message have the potential value for the defense? So these questions are asked all the time. If the answer is yes, or even possibly yes, it should be scheduled and considered for disclosure. So you may have heard a term about unused materials. Unused material means anything gathered but not relied upon at the trial. So this could be anything from body cam footage to extra witness statements, phone data, drafts, rough notes, all of it. It's listed on the MG6 schedule and it's reviewed by a disclosure officer and certified by the prosecutor. If any of that unused evidence undermines the prosecution or it helps the defense, it must be disclosed. Failure to do so has collapsed countless cases, from traffic offences all the way up to the complex cases such as fraud. So transparency here is non-negotiable. So next comes the defense statement. So this is where there's an obligation from the defense. So this is where the defense sets out its case, why they're pleading not guilty, what's in dispute, and the facts it relies upon. It's mandatory in the Crown Court and it's voluntary in the magistrates. But even when it's optional, it's a smart move because it just really shows the other side what arguments you're bringing and how strong you're taking the case. Once served, it triggers a fresh review by the prosecution. They must re-examine unused material in light of the defence issues raised. In other words, a defence statement tells the prosecution, here's what you've missed, so check again. And disclosure isn't just a one-off event, it's a rolling duty that continues all the way up until the verdict. And every time new evidence emerges or a witness changes their account, the prosecution must reassess what's been disclosed. This ensures the defence is never ambushed at trial, and courts view disclosure as a living process, because justice doesn't just stop evolving once the charge is laid. So it's a continual process. Is everything disclosable if it meets that test? Well, there's something called public interest immunities. Sometimes the state holds information too sensitive to reveal. For example, national security intelligence or the identity of a covert informant. Think MI6 or James Bond. In those rare cases, prosecutors can apply for public interest immunity. The judge weighs two interests, the public safety versus a fair trial. So it's that balancing act, and it's quite a difficult decision. Even then, the court will look for middle ground solutions, so redaction, summaries, or gisting the information, so fairness isn't lost. It's a very fine balance. And the message is simple: secrecy must be justified and it's never assumed. So what about a fair trial then? So as you know from previous videos, we're still governed by the ECHR at the time of recording, and Article 6 of the European Convention on Human Rights, guarantees the right to a fair trial, and it demands equality of arms. So both sides having access to the material needed to present their case. When disclosure fails, Article 6 is breached. There's no mean feat. Courts have stayed prosecutions, overturned convictions, and criticised investigators where fairness was sacrificed just for convenience. And this principle sits above every rule. Justice must be seen to be done. So we also need to look at the case management at this stage of the criminal case. So alongside disclosure runs case management and the court's power to control the direction of proceedings. So you've probably seen some of my YouTube Shorts videos. I think some of the cases are being listed for 3 years' time due to the backlog. It's important that cases are dealt with promptly but fairly, and the court is in charge of directing the schedule. Under Criminal Procedure Rule Part 3, judges actively identify issues early, they set the timetables, and they make sure evidence is served on time. It's the practical side of fairness and managing what's disclosed, what's in dispute, and what needs resolving before trial. But the overriding objective is efficiency, fair justice for everyone, and not just endless delays that you see talked about in the news. So when does this timetabling take place? So you've got something called the PTPH, so it's plea and trial preparation hearing. And this is where everything comes together in the Crown Court. So this is just a reminder, just a step back. They've gone to the Magistrates' Court, they've pled either guilty, not guilty, or no plea, and then they come to this PTPH. And here the plea is confirmed. Trial dates are also fixed and disclosure directions are given. Sometimes other matters are discussed as well, such as the expert reports and what experts are going to be used and what witnesses are attending trial. In the magistrates, a pre-trial review achieves the same goal. It's checking the process, compliance, and witness readiness. Directions are enforceable, and missed deadlines can lead to sanctions on one of the parties. And the goal is a clear, managed path to trial, not chaos on the day, last minute. So hopefully that was a useful video. So who controls the truth? In reality, no one person does. The system relies on every player, so police, prosecution, defence, and the court to uphold transparency. Disclosure protects the fairness, prosecution must reveal, and effective case management keeps justice on track. It doesn't cause endless delays or chaos. But when any link does fail, the whole chain of fairness breaks. So what do you think? Is disclosure working, or are there too many cases collapsing through poor practice, and are the backlogs still too long? So drop your thoughts in the comment below. If you have got any questions on this video in particular, or any general questions, then I do try to review the comments. Drop a comment below. But on the next episode, join us for chapter 7. And this is quite an interesting one, inside a criminal trial. So we look at the whole trial and the process of where we follow what actually happens once the trial begins, from the opening statements, cross-examination, all the way up to verdict. So thank you for watching. Hope to see you on the next episode, and it's bye-bye for now.